My name is Jamie McDonald. I am an attorney with McDonald Law Offices. Our firm represents individuals in consumer bankruptcy cases throughout the entire state of Arizona. Today I'm going to discuss with you credit card debt in the context of a Chapter 7 bankruptcy case. Most credit card debt is unsecured debt, meaning there is no collateral securing the obligation. Unsecured debt is canceled, discharged in the Chapter 7 bankruptcy. When the court enters your discharge, you'll no longer be legally obligated to repay that debt. I am often asked by clients whether they are required to list all of their creditors, including all of their credit card debt. My answer is always the same: yes. Federal law requires that you list all creditors in your bankruptcy schedules. You cannot pick and choose. All creditors must be listed. I am sometimes asked by a client whether they will be allowed to keep a credit card after they've filed the bankruptcy. My answer is always the same: not likely. Most credit card companies will close the account whether you owe a debt or not at the time the bankruptcy is filed. Shortly after the filing of your case, your bankruptcy is going to be reported to the credit bureaus. Once the credit card company sees that bankruptcy on your credit report, they will close the account, no questions asked. You'll no longer have access to that account. If you insist on trying to keep that credit card, you do have the option of asking that creditor to reaffirm the debt. I have to warn you, however, most credit card companies will no longer allow individuals, they will not accept a reaffirmation agreement. We at this firm do not believe in reaffirming credit card debt, so we are against it. Credit card companies generally do not offer a reaffirmation agreement. If the creditor did allow you to reaffirm and you signed a reaffirmation agreement, you'll be required to appear in front of the bankruptcy judge at a reaffirmation hearing. It is highly likely that the judge will deny the reaffirmation agreement. Why? The reaffirmation agreement is not in your best interest. By reaffirming on that credit card debt, you're waiving your right to have that debt discharged. You remain legally obligated for it. Therefore, judges, I can't imagine the judge approving that. I'm sometimes asked about paying off a credit card prior to the filing of the bankruptcy. Well, it depends on whether, there's a number of factors to look at in making that determination. If you pay a certain amount to a creditor within 90 days of the filing of the bankruptcy, that payment may be considered a preference under the Bankruptcy Code. If the payment is considered a preference, the court-appointed trustee will be authorized to bring an action against that creditor to recover that payment so that the trustee can distribute it to the remainder of your creditors on a pro rata basis. Even if the payment is not considered a preference payment, however, if you do pay a certain amount to a creditor prior to filing so that you can keep that account, if it's not a preference, it's not likely you're going to keep that account anyway. Like I previously said, when the creditor sees that you filed the bankruptcy, they're going to close the account. So it doesn't make a lot of sense to take let's say you owe $400 on a credit card, you pay it off, you turn around and file bankruptcy, it's under the preference amount, so it's not going to be a preference. The creditor is going to close the account anyway. Why pay it off? You just wasted $400. That $400 could have been used elsewhere, I'm sure. Therefore, I would not recommend doing that. If you have any questions regarding credit card debt in a Chapter 7 bankruptcy case, please give us a call, 480-968-3100.